you everyone for coming. For those of you who don't know, I am Amanda Carling and I'm the manager of the Indigenous initiatives here at the Faculty of Law. I'm going to start by acknowledging the traditional territory of most recently the Mississaugas of New Credit, but historically of many Anishinaabe, Haudenosaunee, and other groups who have lived and shared this land. So that is the first thing. And now I'm going to introduce my very good friend Maggie Wente, who is a partner at OKT, Olthuis Kleer Townshend LLP. If you ever apply for a job there, make sure to spell it properly. She's a member of Serpent River First Nation. More generally, that applies for anywhere you apply for a job. Make sure to spell it properly. Maggie has a broad practice serving First Nations governments, their related entities, businesses, and nonprofit corporations. Maggie advises on treaty and Aboriginal rights in litigation and negotiation, the duty to consult and accommodate, Indian Act matters, reserve land management, and First Nations governance. Maggie also provides employment, labor, and human rights advice to OKT's clients. Maggie has a particular interest in working with her clients to develop and implement sound government policies and practices which reflect their traditional laws as a foundation of self-determining nations. Maggie has appeared in courts of appeal and trial-level courts in Ontario, Newfoundland, and Labrador, and the federal court, as well as before arbitrators and adjudicators in commercial arbitrations, labor arbitrations, and adjudications under the Canada Labour Code. Maggie graduated from this law school with a combined LLB/MSW, and from McGill University with a BA in philosophy. Maggie is the past president and current vice president of the board of directors at Aboriginal Legal Services, and I will never let her go from the board. She was a commissioner at the Ontario Human Rights Commission from 2006 to 2015. She's a member of the Indigenous Bar Association, the Ontario Bar, and the Newfoundland and Labrador Bar. She's often in Goose Bay, but we're grateful that she's here today. So please join me in welcoming Maggie Wente.
Hi, that sounds super impressive. Thank you for that, Amanda. I'm actually just like a crazy cat lady who, whatever, I have a job. I draft bank council resolutions for a living primarily. All right, so Amanda asked me to come today to give a talk about Indigenous governments in Canada, primarily because what that means and is a little bit confusing, I think. So I'm kind of here to just kind of go through various things about various kinds of Indigenous governments, and why don't I turn to the overview page, which will then explain it. Primarily to talk about First Nations governments. So there's a few different kinds of First Nations governments. There's governments under the Indian Act. There's ones under modern treaties or self-government agreements. And then there's nation or treaty-based governmental structures, and then governments outside the Indian Act, which are sort of traditional governments is what we call them. And then I'm going to, if there's a little bit of time, talk a little bit about what governance might look like after beyond the Indian Act, because the current Minister of Justice has said that she's going to move governments out of the Indian Act structure, and it's kind of curious to me what that might look like. And then talk a little bit about the UN Declaration and what the UN Declaration means with respect to Indigenous governments in Canada. Whoa, that slide's not supposed to be there. Okay, so here is a map, which is a map produced by the Government of Canada, the recency of which I actually don't remember off the top of my head. And it details sort of the different treaties and government arrangements within Canada. So I'm sure this has a pointer in it somewhere, but I don't know how to do that. So you'll see here, these are all sort of the numbered treaties, and then in Southern Ontario, there's Robinson-Huron treaties and Robinson-Superior-Williams treaties, et cetera. In BC, that's treaty-less land by and large. Over here in Labrador, this is Innu Nation, which extends into Quebec. This is also treaty-less land. These are peace and friendship treaties. There's Nunavut. There's they're my clients, I should know how to say it. Inuvialuit, Clecho, the Northwest Territory governments. So that's sort of the landscape of what it looks like, but of course not all of, and James Bay and Northern Quebec Agreement, there's not, every First Nation is in the same kind of government structure, or the same kind of relationship with Canada. So what that leads to is an asymmetrical system of how governments work. So if you wanted to kind of make a taxonomy of what rights and privileges people have, the Indian Act Band Council is kind of at the lowest, I suppose, of legally recognized First Nations. Then there's also parallel traditional councils who also don't really have a lot of rights at law or recognition at law. So for instance, an example of that is at Six Nations near Brantford, they have an Indian Act Band Council which deals with decisions to be made under the Indian Act, but they also have a traditional governing council which makes decisions in parallel about most matters or all matters that are outside of the Indian Act decision. And actually, if you're looking at the decisions to be made under the Indian Act, there's actually not a lot of powers really necessarily. Then there's these nation-based groups, I would say. So that's something like the Chilcotin government, which is all of the Chilcotin people who come together and govern over the Chilcotin territory, which has been declared by Aboriginal title. Innu Nation, which is comprised of all of the people of the Innu of Labrador. And also has two First Nations in it, but how it works with respect to the relationship between those two individual First Nations under the Indian Act is complicated, I would say. Then there's treaty-based groups, which are, for instance, Anishinaabe Nation represents the First Nations of Treaty 9 and part of one of the other treaties, and now I can't remember which the other one is. 5. Thank you, Gary Wilkins. Gary Wilkins, he'll be here all day. Grand Council Treaty Number 3, Treaty 8, and there's lots of treaty-based organizations which purport to speak on different topics for the First Nations within their treaty group. Political-Territorial, this is why it's complicated, so tribal councils. The Tribal Council program is actually something that was started by the Government of Canada to provide technical services to First Nations. Lots of First Nations, or some First Nations, certainly within Ontario, use the Tribal Council system also to have a more local form of government or a more local representative for them. So, for instance, a subgroup within Anishinaabe Nation, which is in Treaty 9 territory, there's various tribal councils who work together, and it's usually based on proximity. What they were originally designed to do was to, under the Canada government policy, was provide technical services to First Nations, so for like water treatment plants and engineering services and that kind of stuff. Then there's political territorial organizations, or PTOs. Those might be the same as nation-based groups. Maybe they aren't. So, for instance, Anishinaabe Nation is considered a PTO. It's also a nation-based group, but then there's PTOs that are not necessarily based on treaty affiliation, but might be based, for instance, on national affiliation in some other way, like the Association of Iroquois and Allied Indians, but which is in Ontario, primarily in southwestern Ontario, but the Allied Indians aren't necessarily all Iroquois. And then there's larger provincial groups like the Chiefs of Ontario, the Assembly of Manitoba Chiefs, and then the national group, Assembly of First Nations. And particularly with respect to political territorial organizations, Chiefs of Ontario, the provincial groups and the national groups, the extent to which they are able to speak for or represent individual First Nations that are their members is something that's quite hotly contested, I guess, within the First Nations community. So no matter what kind of fact situation you were to be approaching, if you were working for First Nations or if you were working for, someone who had to government or industry who was interacting with First Nations, it's important to be alive to the fact that you might not be talking to the right person, or that the group that you're talking to might not be the people that everybody thinks has the authority to speak for them. And so that's something that's I'll talk a little bit more about, but it's something that's, I think, quite important when you're working with First Nations to understand. So for instance, I don't know if anyone was paying attention, but a few years ago, there was, the Assembly of First Nations had done a negotiation with the Government of Canada with respect to First Nations education, and had kind of brokered this deal with respect to the First Nations Education Act, and then it came out with AFN's kind of stamp of approval, and all of the First Nations went crazy and said that the AFN doesn't speak for us, they can't give our approval to enact this legislation, and then the legislation eventually died. AFN's a little more cautious now, in my experience. And so, depending on the government structure, it leads to different kinds of bundles of rights and responsibilities that the group will have. And there are, as I said before, groups that are attempting to operate sort of as governments, which combine multiple First Nations with varying degrees of success. So I'll talk a little bit now about terminology. So when I say First Nation or band, I mean like the localist, the most tiny little group of one might talk about. So an individual First Nation, generally a band is something that's created by the Indian Act. And it's the most common form of local government for First Nations. And it applies generally to First Nations who don't have self-government agreements in place. So a self-governing First Nation would be someone who either has a self-government agreement with the province and the federal government, or is under a modern treaty or comprehensive claims agreement, whatever those kinds of things. They're called a variety of things. And then when I say national group, I sort of mean a group that represents multiple First Nations along treaty or national lines. And then the tribal council, I explained, there's some tribal councils which kind of operate like miniature local governments. All right, so the Indian Act band is by far the most common political grouping in Canada. And Indian Act bands, because they're created pursuant to the Indian Act, are generally considered a, quote, like a federal work or undertaking for the purposes of pieces of federal legislation. And they're branched kind of as, they're characterized as branches of the federal government, and as such will fall under various pieces of legislation where it talks about federal works and undertakings. So for instance, the Canada Labour Code or privacy legislation, et cetera, which is a bit of a irritant to me in a lot of respects, because it's sometimes those pieces of legislation were created without apparent attention to what that might mean for an individual First Nation, and those pieces of legislation are often created with a look to sort of, because they generally apply to big organizations or big governments, it doesn't necessarily take into account what a local First Nation government might be able to achieve. So, but it's important to know that for pieces of federal legislation that involve federal work and undertaking, that's something that will probably apply to a First Nation. And they also, Indian Act bands through the common law have a legal personality that allows them to contract, to sue and be sued, generally to borrow money, be a shareholder of a corporation, although I will note that that is not, INAC's view is that they cannot be shareholders in corporations, but we don't necessarily listen to that too much. And what their other powers are is kind of evolves through the common law. And they can't hold property in fee simple, which is an important thing to know. They have to hold it through a corporation. This is about the ability to contract. See, again, also in the Indian Act, it sort of just says this is a band under the Indian Act, and it doesn't set out in the Indian Act what the powers of, or what the legal personality of a First Nation is. So for instance, the ability to contract is something that's been derived out of the Indian Act through common law, but it's not set out in it. So it creates practically lots of problems for for First Nations when they're interacting with parties who aren't necessarily super familiar with the band council structure, because they don't necessarily recognize that the First Nation has the ability to contract, and it can, or the ability to do all kinds of things, sue and be sued, and it can lead to problems. I constantly have banks asking me for opinions that they're allowed to have bank accounts and stuff like that. So. And First Nations also have express powers to enact laws under Section 83 of the Act. So then there's also the kind of, I would say, second most common legally recognized government is a modern treaty government, or a government under comprehensive claim, a self-governing First Nation. So INAC has on its website all of the texts of treaties. So I put up there as an example the Tsawwassen First Nation Final Agreement. And within a modern land claims agreement or treaty, it sets out all of the things that one might want to see for an Indian Act band, like that the nation has the ability to contract, that the government has the ability to sue and be sued, borrow, pledge, own property, all of these things. So the bundle of rights that you get and the certainty of rights that you get under a modern treaty or a comprehensive claims agreement is actually quite a bit more defined and certain for people. And with respect to sort of national groups like the Grand Council Treaty 3 or even AFN, Chiefs of Ontario, those are generally corporations. And there's no federal legislation or provincial legislation, with the exception of the Métis Nation in Ontario, but there's no legislation which recognizes them. So how they have had to operate is through the corporate structure. and and they get all of the legal personality that goes with being a corporation. Occasionally, there are unincorporated groups which work either alongside or kind of independently, and they don't have a corporation, in which case then they're just an unincorporated association at corporate law, basically. For instance, Grand Council Treaty 3 has a corporation which runs all of its affairs and does all of its contracts, but in fact they also have a unincorporated association known as the Grand Council, who makes most of the decisions that don't require a corporate law decision to be made, and then they direct the corporation to make corporate law decisions. So that's sort of a unique structure as far as I found as well. And one of the other questions, I think, which is very important to think about when you're working with First Nations is who holds Aboriginal rights and who can exercise Aboriginal rights. So as you probably know, Aboriginal rights are constitutionally enshrined in Section 35, and those rights are thought to be held communally by the entire group of people, not individual, although they're exercised individually and as a community as well. There's a very good paper by Kent McNeil who wrote a really good paper about who's allowed to assert Indigenous rights or Aboriginal rights under the Constitution, which is on the Osgood Digital Commons site. And then there's also a recent case called Kelly in Canada, which was a 2014 case, and that's actually about Grand Council Treaty 3. And the Kelly case was a case in which the Grand Council Treaty 3 asserted various rights to be consulted and other kinds of Aboriginal rights under the Constitution, and the defendants, who were a power corporation, I guess, and I think the Ontario government, said that Grand Council Treaty 3 doesn't have the ability to assert these rights. It's the individual First Nations who are the rights holders. Grand Council Treaty 3 really disagrees with that. Their political stance is that the treaty was entered into with them as a nation, the Saulteaux people in Treaty 3, and that they should be allowed to continue to operate and assert their rights as a nation. The court actually found otherwise. They said, no, the rights are held and to be exercised through the individual First Nations, but they can sort of, if you will, assign the rights or allow the Grand Council Treaty 3 to assert those rights by Bank Council resolution, which gives authority to Grand Council Treaty 3 to bring an action on all of their behalfs, but it's effectively a representative action. If you are suing or being sued on behalf of or by a First Nation, I think who has the authority to bring the action is something that's particularly vexing at times, and one would think that, particularly with respect to national bodies, et cetera. Another question which I haven't really dealt with in this presentation is the ability of individuals to assert Aboriginal rights or advance Aboriginal rights either as defendants or as plaintiffs. That's a quite complicated question in and of itself, but I will direct you to a 2016 case called Waquan, W-A-Q-U-A-N, from the Alberta Superior Court, or I don't know if it's called Superior Court, but anyway, the Alberta Court of Queen's Bench. Thank you, Carrie Wilkins, thank God. The Alberta Court of Queen's Bench, which my firm had the pleasure of being a defendant in, because the claimants in that sued everyone who had been involved in a settlement agreement with respect to some Alberta First Nations, my firm being one of them. And it has the benefit, I suppose, is the upside of being a lawyer is you get to be a defendant sometimes. But that case has the benefit of setting out in quite great detail who among individuals has the ability to bring a right on, or bring an action on behalf of First Nations. So I will direct you to that. So one of the other features about First Nations governments that I think is important and also speaks to the UN Declaration and what self-determination looks like under the UN Declaration is how you select your leaders. So if you are an Indian Act First Nation, you have 3 different ways of selecting your leaders. You can do it through Indian Act elections, which is not the default, but effectively the default, I suppose. So the default is actually option 2, custom elections. And that's under Section 74 of the Indian Act. So if you never got put into Indian Act elections by INAC, then you are in a custom election system, which is probably the most free system, if you will. You're allowed to make your own custom election code and rules and follow those. Most First Nations got put into Indian Act elections at some point, And if you then want to come out of Indian Act elections, you have to opt out of the Indian Act election back into the custom election system under Section 74, in which case INAC imposes a lot of conditions on you. Indian Act elections are run under the Indian Act, and they have the Indian Act Band Council election procedure regulations, which are fine, I suppose. They're fine. They provide for an election of council every 2 years. The one thing that's, I think, interesting just generally about First Nations elections is, like, I don't know who the first person was who came and decided that the Indian Act election system would comprise, you know, X number of councillors and a chief, and that's what it would look like. But that certainly doesn't mirror the traditional governance systems of a lot of First Nations that I work with. And the imposition of the Indian Act election scheme and this notion of a chief and council just kind of being democratically elected is something that causes a lot of trouble and internal strife within First Nations. So if you go on the federal court reporters, there's a lot of cases about Indian Act elections or custom elections and leadership selection. And, you know, in my view, that's something that is quite irritating for lots of First Nations, because it's not how they would traditionally select their leaders, nor is it how they currently would select their leaders, really, given the option. But so it's something that is, I think, quite vexing. And then there's now also the last option, the First Nations Election Act, which a First Nation can opt into as well, which is a different piece of legislation that governs Indian Act elections. So there are 3 possible ways that you would select your leaders. If you're a self-governing First Nation, you have you control your elections under your treaty or your self-government agreement. You make elections laws. They have to provide for certain kinds of election appeals, and it's generally, there's quite a bit more room to incorporate traditional governance systems. And then as for national groups, tribal councils, sort of more local subgroups, that's going to depend on the nature of the group. So it will have either bylaws if it's an incorporated entity, and the bylaws might try to mimic traditional leadership selection. And if it's a traditional government, it will go by the traditional government's laws. And those are the kinds of things, for instance, I mean, that's something that never shows up in court, quite luckily, or as far as I can tell. So like the Haudenosaunee traditional government system is not something that is really ever the subject of a court action. So I can't tell you too much more about how they work. And then who has the right to select the leader is something that is, I think, politically contentious among First Nations people and groups generally. But for instance, in Chiefs of Ontario, which is the regional group that represents Ontario Chiefs on or Ontario First Nations on a lot of matters, it's each chief of each individual First Nation who then in turn goes and elects the regional chief. Same with Assembly of First Nations. It's each chief of every First Nation in Canada, which then in turn goes and elects the chief. A lot of sort of grassroots people or people on the ground have a lot of problems with that, because they say that there's really no direct democracy allowed, and these people, the regional chief or the national chief, are speaking on have a platform when they don't actually have a mandate from the people who they represent. And then some more local groups do have direct elections that are comprised actually of the citizens who are living there. So for instance, the Mushkegowuk Council is a local group that is directly elected by the people who live there, and same with Indian Nation and surely others. All right, so membership in First Nations. Indian Act bands generally have their membership controlled by, I put Department of Indigenous Affairs and Northern INAC, Indigenous Affairs, and I don't even know what it's called anymore. Anyway, and then some First Nations have the ability to control their own membership. Under the Indian Act, there's a provision to take over control of your own membership list, which leads to some sort of inconsistencies with respect to who is a member versus who is a registered Indian under the Act, but that's a different story. And the membership rules will have to conform effectively to sort of Indian Act guidelines by and large, but you can have band members who are Indian Act members. And self-governing First Nations have much higher degrees of control and lawmaking authority over their membership codes and their membership, who is a member. Ultimately, generally, those are all reviewable by the courts at the end of the day. So if there's a membership dispute, it goes up generally, I think, through internal tribunal kind of process, but ultimately could be appealed to the federal court or I think actually the provincial courts, who has jurisdiction under self-government agreements. And the membership of the national or regional groups is again determined by their bylaws. So Chiefs of Ontario, their membership is actually just the individual First Nations, again, not the individual Indigenous people who live in Ontario. Another feature of is the extent to which a First Nations government is allowed to control Indigenous lands. So the Indian Act allows First Nations to control reserves, right? And the reserves are set aside for the use and benefit of First Nations. And that's really all an Indian Act band has any kind of jurisdiction or control over. And there's, again, two systems of governing lands within First Nation Indian Act reserves. One is the Indian Act system, which is the First Nations Lands Management Manual, which is, you know, if you're ever tired or insomniac, you should pull that out. And then there's the First Nations Lands Management Act, which is a legislative system that you can opt into, which gives the First Nations members actually quite a bit more power over their reserve lands and what kind of developments will occur on their reserve lands. And is more, there's a few Ontario First Nations who have opted into that, not that many because the land bases here are much smaller, but in British Columbia it's quite common to be in First Nations Land Management Act. Ultimately, though, in the Indian Act system, the Crown is the one who gives the lease, the permits, the certificates of possession to allow people to occupy Indigenous lands, and with the permission of the Council. And reserve lands can't be developed without sort of surrenders or designations under the Indian Act, and that requires member ratification. All of that happens under the INAC Lands Management Manual, which is a policy, not a law, I will note, and therefore not as easily challengeable when it's stupid. And so, which it often is. Also, I have discovered recently in the course of a file that the INAC's Land Management Manual is not the only rules that INAC likes to follow when pursuing things like surrenders or designations. There's a whole unwritten rule book, which they may or may not choose to inform you about at any point in the process of you attempting to develop your lands. And the First Nations Lands Management Act is an opt-in system. You have to meet a series of INAC requirements, which are generally about how well you govern your First Nation in order to be able to opt in. And there is generally a little bit more control. You develop a land code, which has some zoning in it, and then you can, and the members of the First Nation ratify the land code or not, and you can have a little bit more lawmaking authority over the lands, and then you can manage the revenues from the lands, which is quite different from the Indian Lands or the INAC system under the Indian Act, which is a little bit, you kind of have to do some go-arounds to be able to manage the money in the way you want. Otherwise, in modern treaties, if you're in a comprehensive claims agreement or a self-government agreement, you have control over land, so there's two kind of prerequisites there. You will have probably varying degrees of authority over various categories of land. So if you think about like a bullseye, like a target, the interior portion would be something called like Category 1 or Category A lands, and the groups that opt into that agreement will have a pretty significant degree of control over things that happen in those lands. And then there'll be outer rings, you know, probably usually Category 2 out to Category 3, where you have varying levels of control over animals, waters, people, so not just how the land is managed and used, but also sort of how people conduct themselves within the land and whatever. So you can actually get quite a bit more power over lands and quite much bigger areas of lands if you're opting into a treaty. So generally, with respect to AFN or someone, you know, Assembly of First Nations or Chiefs of Ontario, those are groups that don't have any authority over lands, with the exception of some, I would say, treaty groups like Grand Council Treaty 3, and other groups possibly that assert that they are the ones who are the stewards of the land and they're the ones who ought to be negotiated and have the jurisdiction to control the land. So, for instance, Grand Council Treaty 3 has a resource law called Manitowaki and Nakanagewin, which is Ojibwe for the law of the land, which is a law that's been enacted by the Grand Council, which they say to governments and to proponents or developers needs to be followed in order to pursue a development within their territory. Untested whether or not any people accept it, and I expect that probably they would be subject to the same problem that they had in the Kelly case about representation and the extent to which they have control over the lands that are surrendered in their treaty. Yeah.
Say the law is enacted under the Indian Act?
No, in the world. The Grand Council made a law, as you do when you have jurisdiction over things. Oh, see, there it is. Even the computer got bored. The lawmaking authority and jurisdiction of First Nations or Indigenous groups also varies widely depending on what kind of agreement you're in. So if you're under the Indian Act, you have a really small amount of lawmaking power under sections 81 or 83 of the Act. You can have a dog bylaw, which there's dogs on reserves and they need to be controlled, so that's fine. Why you can control fur-bearing animals within the reserve. Alcohol, and then there's some really kind of general ones like health or order, maybe like POG powers. Anyway, so they're quite vague. Some First Nations choose to use the quite vague authorities in the Indian Act to make quite specific and interesting laws. So for instance, in BC, there's some child welfare laws that people have used and have been sort of by acquiescence, I suppose, recognized by the British Columbia government. Although my understanding is just recently the BC government has said that they will not recognize those child welfare laws. There's the Akwesasne courts, which I think they have just kind of enacted and they use to settle all of their disputes relating to bylaws within their reserves. And I actually don't think that the Akwesasne courts even operate under the Indian Act. They just kind of operate and people don't necessarily disturb them, and it's quite great, actually. So I tend to advise my clients that if you want to do something, you sort of pick the vaguest possible Indian Act bylaw power, which is something about good government, because you can do it until somebody stops you, right? And maybe no one will stop you because people aren't paying attention. So. Other lawmaking authority comes under the Matrimonial Real Property Act, and then there's, First Nations Land Management Act has some land code authorities. So those are sorts of the general kinds of authorities that Indian Act bans have, but I don't want to really oversell their ability to make laws and govern affairs in their own communities. Case law also recognizes there are some kinds of inherent laws or laws that are outside of the Indian Act maybe, but that's an area of law that's quite in flux and it's long to talk about, but there might be inherent laws that are outside. Certainly those kinds of inherent laws or laws that are outside the Indian Act authorities are the kinds of things that are, for instance, recognized, at least in theory, by the Canadian Human Rights Tribunal or the Canadian Human Rights Commission when they're adjudicating human rights disputes on reserve. And then the custom election law, which is weirdly, if you make a custom election law, no one will interfere with it. The courts will if it's not followed properly, but everybody says it's okay, you've made your internal law and we're not going to bug you about it anymore. If you're in a modern treaty, you have quite a bit more jurisdictional or lawmaking authority. So as I said, it usually changes depending on whether you're in Category 1, Category 2, Category 3 lands. But you'll have authority over a wide range of things, including some environmental management powers, education, culture, language, health, social services. And so you may say, this sounds great, why doesn't everybody enter into a modern treaty? That's because the government doesn't want everyone to enter into a modern treaty. They only want to enter into modern treaties with people who don't already have other kinds of treaties, and maybe not even then. And there's a whole set of costs associated with it, I suppose, which are things you have to give up in order to enter into a modern treaty, which are not as attractive to everybody. The other thing that is not super helpful about modern treaty making is that, of course, in order to run all of these things, you have to do so, you need money to run these kinds of programs. And right now, the federal government's fiscal financing plans for governments who are entering into modern treaties are not super attractive. And so generally how a modern treaty works is it gets set out. It's not like day one your treaty happens and all of a sudden you're running your child welfare system. It's set out and says, you have the ability to make laws or run, this suite of programs or about this suite of subject matters. And then you do what's called drawing down the jurisdiction. So you say, I'm going to draw down my child welfare jurisdiction. But if you do that, you have made a fiscal financing arrangement with the governments that you're kind of stuck with it. And if you don't have enough authority to run, for instance, your own child welfare program because the fiscal financing value proposition isn't super high, you probably won't draw down that jurisdiction, which is actually the case of most modern self-governing nations right now. they're not drawing down a lot of jurisdictions because the value proposition is it's too expensive to run the programs, and they're not getting the kind of funding they need to run the programs. And just so you know, if you're ever talking about this, people may say to you, well, why should they get funding to run the programs if they're self-governing? They don't contribute to taxes. But one of the things is if you enter into a modern treaty, everybody starts paying taxes within a certain amount of time on their income. So you can just keep that in your back pocket. So also you can have enforcement of bylaws. Modern treaty First Nations have to have constitutions as an agreement before it actually comes into effect, the implementing legislation. And there's some control over local justice matters, et cetera. The powers obviously are not absolute, and one of the things that's important, I guess, about the modern treaty making exercise right now is that a lot of provinces are insisting, for instance, that if you're going to make a child welfare law, they're saying in the treaty, before you've even made the law, you can't make the law unless you agree in advance that your law is effectively going to be almost exactly the same as our law, our provincial law, so why bother, right? And that's some of the experience of some groups that we work with who are negotiating modern treaties, say, why would I bother entering into this treaty at all if I can't actually make a law that conforms to what we believe a good child welfare system looks like, and it just has to look like your provincial child welfare system. So coming to the sort of end, I'm going to talk a little bit about how First Nation or Indian Act bans are reviewed by courts and conflicts of laws matters that occur. So Indian Act bans and their councils are subject to the Charter of Rights and Freedoms. So that is obviously a big constraint on their operations. The extent to which they're constrained could be or ought to be tempered by Section 25 of the Constitution. There's not a lot of case law about what Section 25 means and the extent to which, if you have a charter right and a competing Aboriginal right or Indigenous right, what that will end up looking like at the end of the day. First Nations councils are subject to statutory human rights laws generally, and they're subject generally to all federal and provincial laws of general, or federal laws and provincial laws of general application. Carrie can talk about Section 88 because I really can't. And so that's sort of, they're generally subject to all laws. There's no sort of superiority of any First Nation law. In fact, it's probably subordinate. Judicial review of First Nations is generally permitted and generally under the Federal Courts Act if it's a statutory authority exercised under the Indian Act, and also kind of not. I mean, it sort of depends, but generally the case law is saying if the First Nation makes a decision, it can be subject to judicial review for all of the normal reasons one might judicially review something. So for reasonable, or whatever, for reasonableness, procedural fairness, those kinds of things. And counselors, individual counselors can sue or not be judicially reviewed, but they can sue for their failure, be sued for their failure to fulfill fiduciary duties to the First Nation. That's another constraint that's on First Nations, is that they have a fiduciary obligation to act in the best interest of their members. And if they don't do that, the members can sue the First Nation counselors or the council as a whole, saying you breached your fiduciary obligation. So there was a case called Louis a couple years ago about a band member who was suing the First Nation Council because of the way that they had chosen to remunerate themselves. And the member successfully argued that they had not remunerated themselves in a fashion that was consistent with the Indian Act, that they didn't have the authority because they hadn't made financial administration bylaw, et cetera. So that they had decided to remunerate themselves, and that was contrary to their fiduciary obligations to the First Nation. Lots of people think that's wrongly decided, but there it is. It's just a federal court, regular federal court decision. How modern treaty First Nations will be reviewed or not reviewed is always set out in the treaty, what kinds of things can be reviewed. And generally, it goes actually to the Superior Court, not to the federal court, and that's set out in the treaty. Non-First Nations and non-modern treaty governments can't be reviewed, at least by the federal court. They're corporations, so they would be reviewed in the same way that a corporation gets reviewed, which is under the provincial or federal corporation statute, but in the provincial superior court. I actually argued the lead case on that, which is called Pokue, P-O-K-U-E, an Innu Nation. And that was where an individual who was a member of Innu Nation was trying to judicially review the election of the Innu Nation. And I said, no, you can't do that because they're a corporation, they're not a First Nation government. And I was unsuccessful at trial, but successful on appeal, yay. So the thing that I guess is my take home from this is, you have to be really careful that you know what kind of First Nation government you're working with, if you're working with one, and know what their powers and obligations are. And just as a sort of pitch, I think the way the asymmetry of the situation right now is quite vastly unfair. So for instance, if you're in a modern self-government agreement, you have a pretty large suite of ability to conduct yourselves within your territory. If you're an Indian Act band, you have basically next to no ability to really have full control without INAC's oversight. And that is a real problem for First Nations. And it's just sort of a historical accident in some sense about who ran into who and made a treaty with who. And so now when I think about what Jody Wilson-Raybould has said, she's going to dismantle the Indian Act one community at a time. And so when she said that, I was like, that's interesting. Because I don't think that I don't think you can just remove the Indian Act. That doesn't happen because, of course, then you're left with these First Nations who have no legal personality. They're just there in the air. That's obviously not a tenable situation. I expect that what will happen possibly is they will introduce some other piece of legislation which people can opt into and further kind of muddy the waters with respect to what the governance system looks like. To me, that's actually like not doing it in a piecemeal fashion, as she suggested in the media that she will do, is not at all the solution to doing it. Like, you actually have to think about what First Nations governments in Canada generally ought to look like and the kinds of powers that they ought to have, and make it reasonably comparable for everybody. Because otherwise it's just completely unjust and also just incredibly confusing for everybody who hasn't been practicing law in this area for 15 years, right? Or 20 years. And then the one other thing I pulled out in this presentation some of the articles of the UN Declaration about self-determination, and I'm not going to necessarily go through it, but I think one thing that's important is the rights to self-determination and what Indian Act governments or even modern land claims governments look like are pretty at odds. And so it's quite interesting to me to think about the promises of the Trudeau government, which I think we all know are not going to be met, to implement the UN Declaration or to implement the Truth and Reconciliation Commission recommendations, which then in turn recommends implementing the UN Declaration. How they could possibly do that within the current structure of how Indigenous governments or First Nations governments operate in Canada. Because there's things like the right to autonomy and with respect to internal affairs. Well, that's clearly not being met right now because INAC's like looking over your shoulder at all of the wrong times and never at the right times. Means of financing their autonomous functions, that's also not working particularly well. Maintaining their political and social and cultural institutions. So there's plenty of articles that deal with how self-determination and Indigenous governments should work under the UN Declaration. And if we were to really take it seriously, it's not going to be that you're just going to opt out of the Indian Act into some other piece of legislation. And frankly, also the modern treaty structure would be deficient in the way that they structure it now for self-governing First Nations. So I will leave you with that, and you can ask me any question you want. Or you can clap. Go clap. Full applause required.
So we did frame this as a workshop.
Yeah, I appreciate that wasn't workshopping.
Well, this is the workshop part. So with the intention of giving everyone an opportunity to ask Maggie questions and or offer their own thoughts. So please.
You can also just ask me questions about things that have nothing to do with this presentation, like about practicing Aboriginal rights law or whatever. Yes?
I was wondering if you could speak a bit more to the land portion of your presentation, because it sounded really sort of solid that they have these very strong rights to protect what is going on their land, and at least the perception is that, especially with things like the pipelines that are going through there with the let's say, mild disagreement.
Yeah, so, I mean, if the pipeline if you're in a modern, there's not that many places that have entered into a modern treaty, right? Mm-hmm. So that's one. There's modern treaties kind of in the north, in the Northwest Territories, et cetera, in the Yukon. And then there's a couple modern treaties in British Columbia. And there's obviously quite a bit of pipeline disagreement in British Columbia. There's no other, aside from those other couple modern treaties that have been entered into, that's sort of it, aside from James Bay, Northern Quebec. It's not really a modern treaty, I don't know what it is. It's a disco treaty from the 70s. I don't know. And so that's just Aboriginal title land in BC, right? That's land that's subject to a claim, and because it's Aboriginal title land, but it's not yet, aside from the Chilcotin Territory, been declared to be Aboriginal title land, it's just claimed land, then if pipeline developments are subject to the duty to consult and accommodate, right? Which frankly is a bit weak. So they don't, unless you've entered into a modern treaty and that area, you don't have control over it. The Chilcotin are not really letting people do stuff within their territory. Interestingly about the Chilcotin, which is kind of funny, is there's no, we don't really know, nobody really knows really entirely the bundle of rights that Aboriginal title holds with it. And so let's pretend they wanted to ride a pipeline through Chilcotin lands. The Chilcotin government is not really defined in any particular way because it's by court decision, right? So they have Aboriginal title. The government and what kind of rights the Chilcotin government has is a little bit vague, I think, and its legal personality. Well, it has a legal personality as a corporation, I guess. And the bundle of rights that they have with respect to controlling that land, I think, is also kind of up for debate, right? And so the extent to which they're able, they do exercise jurisdiction, but the extent to which there's still, Aboriginal title still carries with it an ability to infringe. So the extent to which they're able to exert their right to exclude pipelines is something that I think, we'll probably learn about in the future. So unless you have a modern treaty, you're not necessarily able to negotiate it. So right now, because BC's unsettled and it's also subject to claim but not entirely claimed, you do a pipeline around all of those, any territory that's not under land claims agreement, and run it through if you wanted to. Obviously, there'll be a huge conflict about that. There's huge conflict about it in lands that are subject to the Siege and Surrender Treaty. There's huge conflict about it all across Canada. And what rights people have over land or what ability people have to control land is something that I think is the biggest issue right now, right? Because people are really, really against the pipelines, not just First Nations people. Lots of people are really, really against the pipelines. And First Nations people, I think, probably have the best shot of trying to stop the pipelines. And so I expect we'll see, quite a bit of legal action. My firm actually just yesterday we represent 2 First Nations who launched an injunction against the Trans-Canada pipeline because they were doing some exploratory digging on the historical pipeline. So I think, but yeah, it does sound great. If the Category 1 lands where you have the most control under a modern treaty are generally reasonably small, but will generally comprise you select it, right? So the First Nations who are entering into the modern treaty select what will be Canada 1 lands or Category 1 lands in concert with Canada and the province. So for instance, we represent First Nations who have an agreement in principle with Canada. They all select together which will be their Category 1 lands, which are generally the lands that are at that core of their harvesting territory or their residential territories, et cetera. So.
Do you consider Nunavut to be a Indigenous government? And how would you compare to, if not, how would you compare to, say, the Niska or other modern agreements in government?
I don't think that, I don't know that much about Nunavut. I have done a little bit of work there, but I'm really not super knowledgeable about it. My understanding of how that works is the Nunavut government is the Nunavut government, and there's there's several bodies up there. I don't think that the Nunavut government is considered self-government by the Nunavut people. I don't think they think that that's their government representing them. It's territorial in some fashion, and then there's other entities which kind of represent the NTI, or NTI Nunavut Tungavik Incorporated, represent Inuit interests there, and then local stuff. But I don't think that that's not the same as the Nisga'a government or the Seychelles government or Tsawwassen or the other First Nations who are governing. It's a territorial government.
Sure, thank you.
Yeah.
You said, on the topic of why are there not more nations who want to enter into want to enter into self-government agreements, and you said because the Canadian government doesn't want to. You also talked about how it can be expensive in ways, but are there actually a lot of cases where First Nations want to start that process, and like what does a bottleneck look like from the Canadian government?
Well, sure. I mean, I think I say they don't want. I think Canada would love to have agreements on Canada's terms for all of the territory of Canada. So, the broadest sense, yes, they want to do that, and the problem is the terms. So there's not the willingness to do it in a fashion that I think respects the way that lots of First Nations or Indigenous groups would want to enter into a self-government agreement. But for instance, if it's already the subject of a number treaty or the cede and surrender treaty, if you will, Canada is not entertaining notions of entering into self-government agreements with those groups, right? So that's it might not be the majority of the landmass, but that's like central Canada, right? They're not going up to Anishinaabe Nation saying like, can we please like scrap Treaty 9, enter into a modern treaty, and you'll have control over this vast portion of land that only you uniquely occupy and we never set foot on. And so they're not doing that. So yeah, that's kind of, so they would like to, but and I think some First Nations or lots of Indigenous groups might like to do that in order to have bundles of rights that are better than their Indian Act banned rights. But again, it has to be kind of on the right terms. So, and I don't think that the terms right now on offer are particularly great. And so in BC, for instance, there was a whole BC treaty process which had been set up, and basically everyone's pulled from the BC treaty process and said we're not going to participate in it anymore.
I'll preface by saying my background in this is very limited, so please correct me if I mischaracterize anything.
I will.
Towards the end, talked about kind of the disparity we see in rights for nations operating under modern treaty versus Indian Act. And then how we need to, moving forward, figure out what our conception of Indigenous government is, or I guess the relationship we want to have between Canada and Indigenous governments. Is it possible to achieve consistency in this while also being sensitive to different types of Indigenous governments?
Sure, I think so. I think you can, by framing it in the broadest possible sense, right? Like, the Indian Act is the worst possible example because it's like, okay, well, you're going to have one chief, and then there's going to be a counselor for every X number of people, and that's how it looks. And the chief is, kind of like a mayor in some sense. He has no more power than the individual counselors, and you operate yourself through band council resolution and whatever, which probably mirrors how some Indigenous society made decisions at some point to some Jesuit dude somewhere. That's probably how I don't know how it came about. But if you have enabling legislation that says like, go and make your governments, and this is, this is sort of your constraints, and this is what your legal personality is, and here are the kinds of things that you can make laws about, and if it was in a consensual way, would obviously be ideal as opposed to just dictating it, but in a consensual way, then people could go and make their governments in the way that they saw fit without the interference of Canada telling them how their government ought to look. And you could come to an agreement about certain kinds of laws, right? Like in Ontario, for instance, there are individual, this kind of goes back to your question, there are individual subsections, I suppose, of law or of areas where people have some limited amount of self-government. So for instance, the Anishinaabe Nation just ratified an agreement about how their education system will work, which is a kind of limited lawmaking power, which is great. But yeah, so I think a lot of it is about kind of having some enabling legislation that then is flexible enough to allow individual nations to kind of tailor it to their own needs.
You talked about, or you mentioned that there's a lot of disagreement between communities about who has authority to represent them in government structures. I was just wondering, can you talk more about maybe like situations where you've seen that become an issue, and if there is any, like what the best way to address it is?
About who has the authority to represent?
Well, like when especially just when there are sort of like multiple potential sources of authority, and it's not.
Yeah, sure. That happens. I mean, it's a really frequent problem in my practice, which is creates a professionalism problem, if you will, because if you're representing multiple First Nations and they and they're all your common client, and they have a dispute as amongst one another, how there's different ways that you ought to deal with that. Yeah, but legally speaking, like for instance, in the Grand Council Treaty case, Grand Council Treaty 3 brought this case, and then a bunch of First Nations, frankly, put up their hands, and as did the respondents, or the defendants, put up their hands and said that, they don't represent us. And how to deal with it is, it's not my job to deal with it as a lawyer. My job generally is if my clients are having a dispute amongst one another, I say, okay guys, like, you need to figure it out and make a decision, and if you can't make a decision, then I can't represent you anymore. And generally everybody, they know that going into it when they're acting. So that's how the rules of professional conduct work in that situation. But no, it's not, I don't think it's necessarily like the lawyer's job to kind of go in and say, this is how you're going to resolve an internal dispute, or this is how this internal dispute ought to be resolved. I think as a lawyer, what your job is to know how those disputes might get resolved, to make suggestions for them to deal with those kinds of disputes under their own laws. And certainly lawyers sometimes represent factions within those kinds of internal disputes, but I don't really think it's.
I wasn't really asking as sort of like what should a lawyer do to deal with that, but just more on sort of broader level thinking about how, like, the best way to structure Aboriginal governance in Canada, and just like that being one of the factors.
Yeah, well, I think that goes back to the point where I think like it needs to be done consensually and flexibly, right? Yeah. Look, nobody ever thinks that there's no consensus in any community or in any polity about the government that represents them, and there's never universality that within a polity that those people are representing all of their needs. That's sort of how it goes. We have to accept that, and I think when you're working with First Nations or small communities, it's much more visible when you see that people are saying, oh, that person doesn't represent me, that person's not representing me well, as opposed to in larger political groups where those voices are not necessarily as loud or they're not heard, right? But I think what you need to do is have I think it speaks to the need for a flexible structure in which people can organize themselves. So for instance, if Grand Council Treaty 3 wants to have some kind of central government and then have local governments, there should be the flexibility for them to do that, and everybody could opt into it if they wanted to. And if one person who is a signatory to Treaty 3 said, nah, we're not into it, then they should be allowed to be not into it, right? Like, I think that's respecting self-determination, right? So under modern treaties, that actually does happen, because usually modern treaties are not just with one individual First Nation, if you will, they're with a number of them. And so what they do, for instance, in the Labrador Inuit Agreement, which is in Northern Labrador, which is settled, they have a centralized government and then they have community governments, and so, which kind of deal with local affairs because there's multiple small Inuit communities in Northern Labrador. So that's sort of one way to deal with it, but I think really the point is to just make it flexible in a fashion that people can choose something. And will 100 years from now people be possibly dissatisfied with how the choices that were made 100 years before? Of course, right? That's human nature, I think.
Hi, thanks for your talk. I wanted to ask more about the bands who are under Indian Act government, but who were under a customary government, who never went under the Indian Act.
Yeah, there's over many of those guys.
Were there, like, where were they geographically?
I don't know. I have some First Nations clients who were never put into Indian Act elections, and so they run by custom election, which is what the sort of legal test for how custom elections work is it has to have broad consensus of the community. It doesn't have to be written down necessarily. But I don't know how many of them never went in. Like, so my clients in Labrador, I represent both First Nations within the Innu Nation. So it's Musqueam Innu First Nation and Shahiji Innu First Nation. Those guys were not recognized as bands under the Indian Act until 2007. And they were never, when those bands were recognized under the Indian Act, they were never put into Indian Act elections, and so they are not under Section 74. They're just two custom First Nations. I have another First Nation who's like that, and it's the same thing. And it's sometimes a little bit hard to figure out because you say, are you a custom First Nation? Because often they're coming to me saying, I want to do my election code. And if they've opted into custom elections out of Indian Act elections, the election code has to meet certain kinds of requirements if they've never opted, if they've never done the back and forth, it can just be what it is. So you have to call INAC, and then they have to like go through their files and discover what happened.
And for those that have opted out, I just wondered if like you could talk a bit about like the variety in governance, like how close does it have to match Indian Act structures, or is there quite a bit of flexibility?
Generally, I've seen it matches Indian Act structures largely it matches Indian Act structures. Sometimes I think I've heard of ones, not ones that I've worked with, that select in a more traditional way, like by family, for instance. So in a way that they would normally do, so like one representative from this family and one representative from this clan. And so that does, I've heard of them. I haven't worked with any of them. But I think in Ontario, if you're in a custom code, generally it has like a Indian Act vibe about it with respect to the composition of council, if you will.
Can I just throw something in as well about this, which I've worked on this for a little while in INAC.
I'm sorry.
Former life. Anyways, the interesting thing about custom election codes is, and it's very true that there are restrictions when you apply to get out, to opt out. There's definite things that need to be done that INAC wants to see done, and basically it's so that the minister is not legally liable should someone get sued. So it goes through the whole process in legal to make sure that the minister is covered. The minister will sign it off when they're satisfied, when he or she is satisfied that there's no legal liability. Once that happens, amending,
You can change your code.
you can change your code.
Yeah.
So the trick is to get out from the Indian Act, and then you create the system you want, and you hope that none of your members sue you, because
Well, that's the problem, yeah.
so if your members are all on board in terms of like, hey, this is our thing, even if we don't like it, we need to figure out a way to deal with it internally, then you can do whatever you want.
Also, super helpfully, the Indian Act doesn't tell you how you get the consent of the community to opt into the, yeah.
So the trick is basically to get out from the Indian Act, according to the terms of INAC, because they're going to decide what you can and
that
can't
is
do,
not
and then reform it a second time to do what you want to do.
Yeah, unfortunately, what happens often that I've seen is that the amending formula in the code has to be requires a rather sort of high voter turnout, and so I've had, like, if you have a community with a large off-reserve population, it's very hard to get people to vote on the custom election code to amend it, so that can be a problem, because INAC requires you, for a good reason, requires you to have a high percentage of people in order to amend it, so.
Yes, so I'm not a law student.
It's cool. It's good for you.
The Ontario Management Board, I'm still not clear on why that organization exists, but did your firm ever have any
Ontario Management Board.
Yeah, it's an odd organization that does have some.
Oh, like the OMB?
Yeah, that's it.
Municipal board.
The municipal board.
That's what it is, municipal?
Well, there's a municipal board and there is something called the
Okay.
Management Board of Canada, which
Yes,
is
yes,
different. but
yes, that's it.
Municipal board.
Carrie used to work for the government too, and we love him still.
Yeah, I guess I'm sadly, because I'm from the States, that's why I got the terms mixed up, but it is the municipal
The
board.
municipal
Okay.
board.
Yeah.
No, I don't have any. The only time we have dealings with the municipal board is when they're about to make some kind of planning or like aggregates related decision that affects my clients. But I don't deal with them otherwise.
Okay,
I know nothing about. Well, I know little. I appeared before them once, but I know not that much about them.
okay.
They would have no jurisdiction over Indian Act bands or First Nation.
No, they don't have any jurisdiction over First
But there's
Nations lands.
no conflicts that your client, well, you just mentioned.
Well, they do sometimes because they have, well, the OMB has, as a tribunal, certain jurisdictions over particular things. One of those things is like Aggregates Act or approvals for quarries under the
Right.
Aggregates Act.
Right,
And so sometimes my clients appear before them because they disagree with quarries or stuff like that. And then also, sometimes there's planning decisions like that we're involved in an OMB hearing because there was a planning decision about a highway that was running up, and we said that the highway that they were considering approval was going to interfere with my client's Aboriginal rights, and that they hadn't they hadn't taken into account Aboriginal rights when they're making the approvals of that. But that's the extent to which we get involved with them.
So I have a question as regards review,
Mhm.
particularly so judicial review of Indian Act laws, like whether they be bylaws or, for example, laws that are then enacted under a land code if it is a First Nation that is entering the First Nations Land Management Act. And like my understanding is that if you look at the land code structure, like once a First Nation has a land code in effect, they will most likely, they're either obliged to or will likely enact some sort of administrative body which will make decisions. Like vis-a-vis their own codes and any other sort of like land laws that are then enacted. But say someone within the First Nation challenges that, then it goes up to review. But the law itself that was enacted by the First Nation, the principles, the legal principles in that law are their own Indigenous legal principles. And for example, like a white guy on the federal court has no understanding of like a Haudenosaunee legal tradition and how is he or she, let's say either, like able to actually interpret that. Like I think right now we don't see a lot of cases like that, but I wonder.
I'm with you.
As more First Nations are doing this, and I think it's so important, but what's going to happen with all these review decisions?
Well, so it's the kind of thing that happens in custom election code. So because there's no, in the Indian Act, if you're in an election, there's an appeals procedure that goes through the Indian Act and the minister can make a decision. In a custom election code situation, they have, depending on how they came into the custom election system, will have either an appeals board or not, but often custom election codes go up to the federal court for review. And my advice is like, as much as possible, generally try not to have the federal court tell you what your law is, right? Like that is a go nowhere move. Unfortunately, it happens all the time because people have disputes about elections. But I agree with you that it's like, I don't think it's a particularly effective thing to have the federal court start telling First Nations or interpreting First Nations laws. Unfortunately, it happens. I mean, and then you're in the position of leading evidence about what their law is, and it's not ideal.
I think just to add on it, and I sort of wonder too with sort of the Minister Listener goes talk about sort of the Indian Act being a thing of the past at some point in the future and sort of more and more nations enacting their own laws. Would there then at some point be sort of an own like judicial review body of the Indigenous nations of Canada where sort of the trying to kind of visualize something totally radically different than First Nation laws at some point in the review cycle being put into the general Canadian common law system of review, or that would even like create a further asymmetry and differentiation, like in your own sort of visioning of what you think may be in 20, 50 years. Have you?
Oh, I don't. If I knew the answer to that, then I'd be Minister Wilson. No, that would be nice. Obviously, it would be nice if there was sort of a shield from review. I mean, I think that generally I think people would think it was like somehow anti-democratic to have it shielded from the review of the Canadian courts. I can't envision maybe in 50 or 100 years that somebody would be so humble as to suggest that they shouldn't have the final say, but I don't think that the Canadian government is in that position to kind of say, we're okay, you guys just like make your decisions yourself. Which actually the only time they do that is in custom election. If people go to INAC and say I'm having a custom election problem in my community, they're like, okay, well we don't have anything to do with that. Like the only time they do that. But I think it would be nice if people were to settle disputes or that they could form their own tribunals. So for instance, like the Anishinaabe Nation, they have a dispute resolution mechanism that's internal to them for certain kinds of disputes, but I think ultimately probably, those kinds of things can be reviewed by the courts if it came down. Because lawyers are lawyers. Like, you can have the privative clause like up the wazoo for any kind of internal First Nations appeal board or whatever, but lawyers are lawyers and they're like, I'm going to appeal this because your privative clause doesn't apply to me. Carrie.
There's an interesting precedent about this in the Hutterite context called Lakeside Hutterian Brethren against Hofer.
The religious cases have.
Yeah, it was an internal dispute within the Hutterite community. Mr. Hofer was deemed, who had signed a contract to be part of the community and all his worldly goods belonged communally to the community. He was deemed to have misbehaved and the community wanted to banish him. And so he took that all the way to the Supreme Court of Canada. And it was a 5-4 decision, and I can't remember which way it went, but what was really interesting was that both sides applied a highly deferential standard of review to the internal workings of the Hutterite community. It was a case about procedural fairness, so it was interesting that they did that. And I think the difference was the majority was either a little more or a little less deferential than the dissent. Depending on which
That's
way
good.
it
I'll
goes.
go back and look at that. It's funny because you're right. As soon as you said that, I was like, that's right. There's all these church cases where there's like these internal church disputes or mosque disputes or religious group disputes, and they're like, we're not going to get involved in that.
So,
Yeah.
I mean, it would seem to me to be arguable on behalf of an Indigenous community that if somebody decides to bring the mainstream courts into the conversation, a highly deferential standard of review would be appropriate because the expertise on the laws of the community lay within the community.
I'm keeping that.
Am I missing something?
No, you're quite right.
Okay.
Yeah, I think that's great. Thanks, Carrie.
So I'm a PhD student, not in law, but closely related legal history. And one of my projects is on the end of the Indian agents in the 1960s. And I think that their removal and withdrawal from councils and like actual on-site supervision of nations happened over like kind of a 15-year period. I'm hoping our former Kayanak friend could maybe speak to us a little bit after you do. And I'm wondering, when you're drafting BCRs and things like that now, what does that type of supervision, because I know it was kind of just a lateral move, they're in all the legislation still, the superintendent word and everything like that. What does that really look like? Because the agent used to run the meeting, kind of supply the BCR in advance for his plans, as you know the department had instructed him to, and then it was passed through. And obviously, you're drafting BCRs on behalf of, you know, to do wording and things like that on behalf of First Nations, and it's a different whole process and different type of.
Yeah, the Act now doesn't require that
but-
BCRs be approved in any fashion. And in fact, actually, it used to be that Act required that if you enacted a bylaw, until like last year, if you enacted a bylaw, the bylaw had to be like, go to INAC for review to either be allowed or disallowed or whatever, like good comments on it, and that doesn't exist anymore. Now you just have your bylaw, you publish it in Gazette. We're not going to oversee you in any fashion. So, I just kind of proceed onward and don't. There's no sort of requirement for the Indian agent or the superintendent. I mean, there's some kinds of things, but it's not ever a part of my daily practice where I think about the Indian agent.
Sorry, just back to the BCR is band council resolution.
Band council resolution, yeah. So under the Indian Act, the powers of the band are exercised by a majority of the council under a band council resolution, and in fact, theoretically, all powers of the band have to be exercised in that fashion. What I do is generally at the beginning of a council, when they get elected, I draft out whose authorities are what and who can execute what, and try to get them to have that so that they don't have to sign a BCR at every instance, right?
Can you talk about some of the challenges of enforcing the laws
that
are created by
Yeah, so sure. So the biggest enforcement of laws problem that we have is the alcohol or intoxicants bylaw problem, and that's a problem. It depends a lot on your local police force or your local county attorney or whatever. But in Ontario right now, there's lots of First Nations in the north have dry communities, so there's no intoxicants or alcohol or whatever allowed in their communities. And you can get searched as you get off the plane or bring your boat in or whatever. And then you could get prosecuted. So it's like a provincial offense, effectively, under the bylaw. But Ontario will not prosecute the bylaws right now. They will not. No one will do it. Some justice of the peace somewhere in Dryden was like, no, I don't have the authority because this is a federal law, and you would have to take it to the federal court, which is obviously lies, because you can enforce a provincial law in the provincial, anyway, whatever. Federal laws get enforced in provincial courts all of the time. So some justices of the peace did that in Nan Territory, and then they're like, well, we're just not going to do it anymore. And then the police are like, well, if they're not going to do it anymore, then we're just not going to start enforcing the bylaw anymore, which is a real problem for First Nations who, regardless of what you think about alcohol bylaws and their efficacy, it's a huge problem for First Nations who want to have exercise some kind of territorial control. And the other part where you would see that is in trespass bylaws. So the trespass bylaw is the way that you can exclude people from the community, which you have the authority to do under the Indian Act. And if no one's going to help you do that by prosecuting trespassers, who are really the people who usually get banished or off the community, or drug dealers, but if no one's going to help you do that, then effectively you don't have the ability, even though you might have it in name. My understanding from the Minister's office in Ontario is they are looking at an enforcement project now to kind of get that back rolling again. That's what I heard.
Related to that, for residency bylaws that would be enacted under Section 81 of the Indian Act as well, I've come across discussions in a First Nation of permitting, especially if it's a nation that has a lot of cottaging communities. A lot of folks have had holdings, sort of the present day iteration of CPs, right? But they have to agree with the First Nation where the family for decades has been coming up and they just cottage there, and that's all fine and well. But in sort of enacting residency bylaws, there is a discussion about to what extent might we want to have visitors permits and actually have that be a form of revenue for the First Nation. Right. And there's interesting community conversations about that. But have you ever come across that with any?
No, I had a conversation with a First Nation recently who was interested in. Because there were a lot of local non-Indigenous people or people from other First Nations coming onto their reserve to hunt on their reserve, and they were like, we'd kind of prefer you not hunt on our reserve, and so they were asking me if there was anything that they might be able to do, which I think they can very easily control who gets to hunt on the reserve, but not just, generally people, they don't try to regulate too much who can just be on the reserve. I mean, theoretically they have like a territorial ability to exclude, but nobody really does it. It's just the drug dealers and the peddlers, the energy resellers, those people. Those guys who come to your door and try to sell you a water heater, they're really into going on to First Nations and swindling old ladies who don't speak English.
So the last closing comment / question that I have, there are a number of opportunities for students who want to get summer jobs, either within working in Indigenous governance, there are fellowships available. The 2E fellowship is open to Indigenous and non-Indigenous students who want to do a placement with Indigenous governance. There's also the Debwaywen Summer Program that we had an information session about last week. And there's a Colwood Fellowship, which is open to Indigenous students. And then you can also apply for an SLS Fellowship or a Donner Fellowship to do some of this similar work. So I thought maybe you could offer some tips to students on putting their application packages together when you're applying to someone in the area of Indigenous rights law.
Thanks, Amanda. Amanda just heard me rant about this today. So I'm in the process of reviewing applications to be associates at my law firm. And I will tell you that the thing that is the most irritating to me when I receive an application from a young lawyer who wants to be an associate at my law firm is having a long cover letter which describes to me how interested they are in Aboriginal people and how much they think that this would be personally rewarding and fulfilling for them. I need to know, if you're doing this, why you are of value to my clients or to my law firm. Lots of people would find working with First Nations a personally rewarding or fulfilling experience, but you need to kind of go a little bit beyond that and think about what it is that you might have to offer a community or somebody who's working with a community. Like it's not tourism, I suppose, right? Like it's not cultural or poverty tourism. So like I get that there's lots of non-Indigenous people or even Indigenous people who would like to work with Indigenous groups and maybe don't have a lot of experience with them. This is a great way to get some experience, but you have to really think, if you don't have a lot of time working with communities, what it is that you have to offer. And make that sort of a primary focus of what your application might be, as opposed to how my law firm or any other organization might enrich your life. So that's my tip.
Okay, well let's clap again. Thank you very much.
Thanks, everyone.